Welcome to the Zen Game Podcast. I'm Tommy Morris. Normally, we get inside of the minds of your favorite college athletes, but today we're going to get inside of the mind that all of your favorite college athletes want to get inside of the mind in. I'll let you introduce yourself, Darren. Tell the people who you are and why it's a good big time for you, I guess.
Well, first of all, thanks so much for having me. As you mentioned, my name is Darren Heitner. I'm born and raised in South Florida, currently live in Fort Lauderdale, Florida. I've been practicing law for roughly 16 years. I've had my own law firm, Heitner Legal, for approximately 11 years. Graduate of the University of Florida and University of Florida Levin College of Law, but currently teach NIL law at University of Miami School of Law. And my practice primarily focuses on sports law, intellectual property issues, contract drafting, review, negotiation, civil litigation, and arbitration.
So NIL law did not exist 5 years ago. So I'm going to ask you, how did this happen for you? Because you paved a path for yourself in a field that didn't exist in 2020.
It's really interesting, and you're not alone in coming to the assumption and belief that NIL law didn't exist as of 5 years ago. I think a clarification is needed because NIL, name, image, and likeness, is really a subsection of an individual's right to publicity. And without getting too far into the weeds, every state recognizes an individual's right of publicity, which derives from an individual's right of privacy. And essentially, it allows an individual to commercialize his name, image, likeness, and other items that are consumed within this right of publicity, and also prevent others from misappropriating that person's right of publicity for commercial gain. And what's really interesting, and what has been very interesting from my perspective, is that literally every individual in the United States has had these rights really for roughly a century. Yet, college athletes in particular, and also really high school athletes, had been carved out from those rights, either based on NCAA rules or state high school athletic association rules, respectively. And it wasn't until July 1, 2021, which is why you indicated 5 years ago, that all of a sudden the NCAA eased off its grip of those rights and allowed athletes at the college level to start benefiting from them. But to your question of how I was able to get involved, I had actually been litigating more general rights of publicity issues well prior to July 1, 2021. I had been writing quite extensively, whether my former job at writing at Forbes or writing on social media about the inequities of not allowing college athletes to benefit like every other individual from their rights of publicity. And I had been practicing for over a decade in sports law. So I had the relationships built with athletes, with agents, with brands. And it just so happened, going back to 2019, I was asked by a politician, Chip LaMarca, and his legislative aide, Corey Stanicia, who represented my district in the state of Florida, if I'd be interested in working with them on legislation that would supersede those NCAA prohibitions at the time. So that really, all those things mixed together, I think really helped me put myself in a position to where I'm now working so much in the space.
So can you help people kind of understand how I believe that obviously the initial purpose of NIL was I have a million followers, I should monetize it. It has now turned into what is something completely different. So can you help us walk us through how the path got from I just want to be able to monetize my social media to now we have collectives and now we're doing rev share. Like how quickly did people realize like this is something that can morph into something else?
Extremely quickly.
That's what I
Uh,
figured.
it was actually July 1, 2021, when I received a direct message on Twitter. It was called Twitter at the time, from an individual named Eddie Rojas, who played baseball at the University of Florida, was considered a booster of the school because he provides money to the program. And in short, he messaged me and asked if there was a way that he could develop a platform that would allow the fans more access to players through a subscription model, where they could pay different tiers of money, either monthly or on an annual basis, and get certain things like in-person appearances, autograph opportunities, virtual meet and greets, etc. with the overarching goal that it would create this reservoir of capital that could then be reinvested for the athletes. And lo and behold, this concept was originally named GATR Collective. So when you now hear about all these different collectives in the NIL ecosystem, it's actually a byproduct of that brainstorming by Eddie Rojas, literally on the day that the NCAA decided to ease off of its regulations and blanket prohibition on any NIL payments whatsoever. But going back to that date, the NCAA had put in place certain guardrails, including one that payments can't be in exchange for play. That line has certainly been crossed, and not only by collectives and boosters, et cetera, but even today in 2026, with colleges now having the opportunity to pay players directly as a result of a case called House v. NCAA and a settlement there too. Uh, these contracts allegedly are not pay for play, but they have the look and feel of it. And certainly the players are getting compensated based on the premise that they are going to provide those services to the athletic programs, which the programs hope will in turn lead to a winning record.
Yeah, and I mean, so I personally, when it first came out, that this is all legal. I my brain went to, well, what is something that is a subjective cost, right? Art. Like, why not just have a full your full football team do oil paintings or whatever, and then any booster can pay any amount, and who's to say that's not what it's worth? And now that's their job, right? I I feel like that loophole turned into, we'll just pay them outright. You know what I mean? Like, because there's all this other stuff that people are doing that is clearly not probably what the value is, but there's no way to put a number on it, right? And I think they tried to at some point say, because with the social media posts, oh, like this amount of followers should amount to this. But same thing, if I think that it's worth $1 million to my company, who's to tell me it's not?
That's the rational, logical view, right? Because if you want to buy the Philadelphia 76ers, no one's going to prevent you from paying what some may perceive as above market value for the team if that's how you perceive the value to be, right? There's no arbiter who determines what fair market value is really in any industry and can kill a deal based on someone deciding they want to pay what is perceived as above market value. And for a very long time in this space, and I say very long time, even though we're not even a full 6 years in. So the industry in the NIL industry is still very much in its infancy and sort of figuring itself out. But for the long time, there was no real arbiter to determine fair market value. And that made a lot of sense for the reasons I just stated. But also, if we consider that House v. NCAA settlement, which opened the door to direct payments from schools to athletes, which this past fiscal year is to the tune of $20.5 million dollars and is going to gradually go up year over year. That settlement also led to the creation of what's called the College Sports Commission. And the College Sports Commission is funded by the conferences, by the NCAA, and the schools that opted into that settlement. The College Sports Commission also controls this technology called NIL Go. And now all of a sudden, athletes are required to submit all of their deals that are not the deals that are provided by the schools that are in excess of $600 to this NIL Go platform. And that NIL Go platform is charged with making a determination of number one, whether there's a legitimate business purpose surrounding the deal, but number two, whether it's fair market value. And a lot of deals have been approved. Some deals have been rejected. Many are in purgatory. I think it'll be very interesting to follow what happens to those deals that are in purgatory. And if any of those deals that end up being denied are challenged, particularly if they're denied based on this fair market value grounds, because I think it's incredibly difficult to justify based on the inherent subjectivity surrounding that analysis.
What would have to happen for something to get denied? Because, like you said, it almost feels impossible. It's hard for me to believe there'd be anything that'd be denied.
We haven't personally dealt with it. I work with some collectives, I work with many athletes and many agents, and certainly we've seen a lot of deals approved. We have plethora of deals that are stuck in what I refer to as purgatory. We haven't personally dealt with any denials to date. There is an arbitration system that was also put into place if there are to be disputes. Once a deal is denied, there's an opportunity to renegotiate the terms and or to escalate it to arbitration. My understanding, based on the most recent report from the College Sports Commission, is that there have been about two handful of cases that have gone to arbitration or that were supposed to go to arbitration, all from the same school and all based on a technicality, with the vast majority of them resolving themselves. So it's certainly something to keep an eye on, because I suspect there may come a point where some of these issues do go through the arbitration system, and or the arbitration system is challenged in and of itself, or third and finally, there's an arbitration decision, and then whomever loses decides to try to petition to vacate that arbitration award in a court of law. So stay tuned.
That is all way over my head again. I hardly made it through a remedial reading. So for me, being a lawyer is never in the cards. Well, let me try to put the lawyer hat on for a second, though. So, because in theory, if there could be playouts being compensated for either appearances or social media posts, in theory, the bigger following should get the most money. That we know that's not how it always works. Putting the lawyer hat on, is there a case to be made that a company can say, we are projecting that athlete X is going to be more visible because they're going to be on TV more, all this other stuff. And even though they're not necessarily promoting the product while they're on TV playing their sport, they will get more eyeballs later than whatever that number is now because we anticipate they're going to be in the national championship game or blah, blah, blah. Again, it's really hard to subjectively or objectively say this person's supposed to be worth more than this person.
Yeah, I think you actually answered your own question in all of that. Who is in any position to be the arbiter of what is fair value? And more importantly, there's no one element that is either necessary or even or that is preferable to use as a deliverable in any of these contracts. I mean, you're referring to social media, and certainly that is a very prominent way for individuals, whether they be athletes, celebrities, etc., to provide value to brands in endorsement deals. But it's not the only way. And I think I recently had a conversation with a collective operator that's actually considering going away from use of social media, because it is so subjective as to, the value that you're getting from a social media post. In today's day and age, a lot of followers are actually purchased, and you know, it- not having engagement metrics at your fingertips also don't necessarily allow brands to understand how much value and return on investment they're receiving. And also, in terms of actually performing on deliverables, what that's easy for anyone to track. If an athlete doesn't actually post content on social media and that was a deliverable, that could pose a problem. Whereas if you have other deliverables that are not as easily monitored, who's to say that the athlete didn't perform? But yeah, I mean, an athlete's value doesn't necessarily come only from social media or at all from social media. There are very successful athletes who are extremely recognizable and have done many things to build very strong reputations, particularly in local and regional markets, that can provide a lot of value on billboards and in TV advertisements and other internet advertisements where they're not actually taking the initiative to post on their own social media. Are those actions not to be valued? I mean, oftentimes you're getting a lot more value as a brand from that than you are from a random Instagram story.
That's a good point. And we talk about this now from sort of the side of the companies, the schools, but now to the athletes, because this is really, I think, where there's a huge lack of education. So we hear all these giant numbers, right? So and so quarterback's making $5 million next year, blah, blah, blah. When we hear those numbers, how much of that from what you've seen is actual money and how much of it is a $5 million package that then includes rent, a loaner car, flight tickets, whatever. Like, how much of it is real money? How much of it is sort of like and goods?
Most of it is real money. Oftentimes the numbers though that are published are not fully guaranteed dollars. Sometimes you see reports that an athlete is making X, but really it's a smaller amount with the capacity to earn that greater number, determined on various factors. Oftentimes, participating in a certain number of games, even though technically it sounds like pay for play, or helping lead the team to a conference championship game, or winning the conference championship game, or making a bowl game, or the CFP, the college football playoff, which, again, seems like you're getting pretty close to pay for play, but these are things that are actually being included in contracts. Uh, the there are sort of in kind benefits that some athletes are receiving, whether you mentioned like rent or a car, etc. But from what I've seen, those typically are not factored into the numbers that are being reported.
Got it. And then I'm sure you've seen some horror stories, right? Because
Hmm.
my biggest issue with this whole thing is there's a lot of agents out there that are not really agents and or don't have any sort of experience. They just happen to know the athlete. How many times, if you're just to guess, percentage wise, an athlete's going to the portal, going to new school under the assumption they're making a certain amount of money, and once they get there, they find out it's not actually all it seems. You know what I mean? Like how often does that horror story happen? Because maybe there's been a miscommunication or the supposed agent has made a mistake along the way.
Far too often, far too often.
Yeah.
And yes, there are certainly many occasions where agents can and should be blamed. They're oftentimes only looking at the compensation section and glossing over the remainder of these contracts that can be 15, 20 pages in length and, size 8 or 10 font, and are very one-sided and drafted by extremely competent lawyers on the other side, particularly with these NIL license agreements now in place from the schools. You're talking about very seasoned lawyers in the form of general counsel who are oftentimes drafting these documents. But it's not just that where you have agents who are really not prepared to handle these intense, high profile negotiations. But there's also just so many athletes who aren't even represented, whether they be represented by agents or counsel, that are just signing whatever's put in front of them. And year after year, the amount of issues that I'm dealing with is growing, and it's doubling, tripling, quadrupling. I mean, it's really getting worse by the year, and I suspect it's only going to continue from here as I've seen the contracts get even more one-sided year over year, and I'm noticing a lot of athletes don't even realize what they are signing. At the same time, I would argue that the parties on the other side should reconsider how one-sided they want to make their contracts, because the more illusory or unconscionable that they are, including terms that may not even be enforceable, I think and the more ambiguous some of the language may be, uh, the more likely that these issues can turn up becoming disputes. And I think also the more money that's on the table, obviously, the more incentive there may be for someone who feels as though they've been wronged to escalate a matter.
You're an athlete, you're thinking about going to the portal. You know that you're going to get compensated in some way, shape, or form. You may not be the all-star, you're not bottom of the barrel, but you're going to make a decent amount of money. Advice you would give that kid from the time they decide they want to go to the portal to the negotiation process till they also end up in their final destination. What are the mistakes that you've seen along the way of that process?
Well, one goes back to what we just talked about, inexperienced agents. I think you, as an athlete, conduct your diligence, start early, make sure you're asking all the right questions of the agent. Have they been fired before? How many contracts have they done, at the professional level, at the college level? Some of the things that they look for in contracts. How many people at that position are they representing? How many people do they have currently under management, et cetera? How many people do they have working for them? And there's so many questions that can and should be asked. So that's very important. And start the process early. I mean, obviously, technically under the NCAA rules, there should not be any communication with other schools until the portal opens. But the reality is almost many players know where they're going before the portal opens up. If you're not one of them, you're late. And I think you should rely on an experienced agent who has a lot of relationships, a lot of connections to really figure out where the destination is, probably before the portal even opens up. If you know where you're going, you could certainly enter with a no contact tag. Although I don't really, I know a lot of athletes have done that. I'm not sure there's much of a benefit to it, particularly because I've found quite a few athletes in the recent past deciding that they're going to commit somewhere and even enroll somewhere and then decide that they maybe want to go somewhere else. And so I don't see a lot of benefit from using a no contact tag. But I also think it's very important to really conduct that diligence not only on the agent, but on your potential destination. Start negotiating your contracts early. Don't wait until after you're enrolled because you're losing a lot of leverage. I mean, the portal's closed and I'm still getting contracts today to review. And it's difficult because I review those contracts and I see a lot of things that really need to be changed. And yet I also understand that the athletes lost a lot of leverage because the portal's closed. So the only other option for the athlete is to unenroll and enroll elsewhere, which we've done before. But it becomes more challenging as the semester goes on. So those are just some considerations to take into mind as the portal's opening.
Yeah, and for an athlete that happens to, 'cause I think for football there was like 6,000 in the portal, and then there was like 1,200 still stuck there when all the musical chairs was all filled up. What would you advise a kid who's one of those 1,200 who's now just stuck floating around? The semester's already started. They got to go back to school somewhere, but their spot's now gone. What's the best course of action if you're one of those guys?
Well, and let's think about the reality too, because I think the media oftentimes forgets to note that a lot of players who are entering the portal are doing so because they don't feel as though they've had a choice. Like they're sort of getting pushed out of the program in which they previously belonged. It's not grass is greener in every circumstance. Um, so that's number one. Um, but number two, I mean, if an athlete has an opportunity at his current school, can remain on athletic scholarship, but may not get the playing time that he wants, it's preferable to being trapped in the portal and leaving and not having a home. And again, I hate to sound like a broken record, but that goes to the diligence. And don't necessarily take everything that your agent says to you at face value because yes, agents are supposed to be fiduciaries to their athlete clients. The athletes are the principals, and they're always supposed to act in the best interest of their clients and not be self-interested. But at the end of the day, agents aren't making any money unless they're negotiating a contract. And so oftentimes, especially if that agent didn't negotiate with the school in which the player is currently based, that agent may be pushing that player to test his luck in the portal. And sometimes, the unfortunate consequences, there's no home for the player.
I'm gonna ask you to role play here a little bit. You're the commissioner of the non-existent NCAA football whatever league, right? How would you structure this so that it's not so out of control every year where it feels like everybody's a free agent and everyone's going around anywhere? How would you what's like the best way for this to end up?
Well, the challenge right now is based on inaction for such a long time that there are actual court decisions that limit your capacity to make changes to the system that could create and result in, I guess you could call it, more normalcy. You have the Ohio v. NCAA case where state attorneys general sued the NCAA because previously a player could only enter the portal once and change schools and play immediately before having to sit out. So if it was a second, third, fourth time of transferring, the player would actually have to sit out a year. And through that case, it opened up the door for players to transfer multiple times and play immediately. You can't put that cat back in the bag. Uh, Additionally, there's the Tennessee v. NCAA case, also brought by various state attorneys general, where previously the NCAA had tried to limit inducements to limit the amount of communication between boosters and collectives with players prior to the player's enrollment at an institution. And once again, the NCAA lost at the preliminary injunction stage. I think it's an incredibly difficult challenge for anyone who would be in that position of, commissioner of college football, let's say. You
Can
can't
I give you the Tommy Morris idea that I've been trying to pitch a million times, and you tell me dumb idea, bad idea, or something's close?
absolutely.
I think because I'm trying to be mindful of your time here, so I want to get to this. I gotta get to this at some point.
Okay.
Um, here it is. So I think that there is, from my perspective, there's no way this doesn't end in players somehow being employees. It just doesn't. I
Right.
know they don't want that because then they can unionize, and then it opens up a whole other can of worms. Here is my genius brain idea. You give the athlete two paths they can go. They can go the full employee path or the student path. If they're a student, they're basically saying, I value the education. The idea to me of transferring 4 times and still getting a diploma doesn't make any sense. In order to protect the player from having to transfer a billion times, they get the free education. They still can be paid. They only get one transfer in order to protect them from themselves to make sure they actually graduate. That's the athlete path. And then once they graduate, they can go against. They can be a grad transfer. The employee path is I'm not going to go to school. I have no interest in the diploma. I'm just going to make the money part and I can transfer as many times as I want. And in that way, you give them two avenues because, again, the other thing that gets lost in this is the fact that they actually have to go to school. And as you may, everybody knows people who've transferred from college to college at least once, just for as an academic person, you lose a lot of credits. So for the athletes to transfer 3, 4, sometimes 5 times, it's inconceivable to me that they'd end up finishing with a diploma. And now, if you don't play in the pros, you're stuck with nothing. How is this a dumb idea? Decent idea? Is it
It's
way
a
out of left
complex
field?
idea. It's certainly you've thought about this for a little bit, that's for sure. I think you'd actually be surprised by the number of athletes who have transferred multiple times and have actually graduated, and how graduation rates have been affected in a positive way based on the fact that so many athletes are staying in school because there is this new opportunity to make not only money, but a substantial amount of money, and oftentimes more than they would make in the NFL or in the NBA. And it's guaranteed, let's say, on the football side, to a large extent, typically for college players, as opposed to players who are in the NFL. Um, I do think, going back to my commentary before, as potential commissioner of this college sports or
Oh, I
college
forgot, Mr.
football.
Commissioner. I forgot. Yep, go
Well,
for it.
no, no, it's okay. I mean, you wore the hat well and played the role well.
I was the interim for a good 5 minutes there.
I I think employment could be a fix, although I just saw that Senator Ted Cruz, and probably any bill that would ever pass through Congress would have to go through him, said there will never be a bill that reaches the floor or gets passed unless it includes that athletes are not employees. Uh, Otherwise, if Congress doesn't act, I think that's a decision that will ultimately be decided through the judicial system. Um, there are complexities surrounding employment, public versus non-public schools, and the different ways that each state recognizes rights, and whether schools can even classify the athletes as employees. Um, but that could be a route where you, if athletes want to also collectively bargain, and through bargaining, establish rules that are immune from antitrust scrutiny. Similar to how it works with the NFL and the NFL Players Association, and the NBA and the National Basketball Players Association, and the Major League Baseball and the Major League Baseball Players Association. The reason why those rules aren't challenged is because they're bargained for with the actual players, and you don't have that currently. And that's why, to your comment earlier, the NCAA seems to be losing over and over again because it's implementing rules, and it's allowed to implement rules, but under an antitrust analysis, which you have when there is not bargaining, these rules have to show that they add to the pro-competitive nature of sport, that they're beneficial from that standpoint, that they're not unduly restrictive. And the NCAA has been challenged because they seem extremely restrictive when they try to inhibit athletes from earning their true value, which is whatever anyone will pay them. And ratings continue to go up year after year, despite the claim from the NCAA that all of these rights that the athletes have gained over the past few years would cause the end of college sports as we know it. So it's a really tough spot for the NCAA to be in, and it would be a really tough spot for any commissioner of college football to be in. And that's why you see over and over again the NCAA begging and pleading Congress to intervene and actually give the NCAA an antitrust exemption because it feels like it's between a rock and a hard place.
Last question I'll ask you because I know you got to get out of here. The future of this, not necessarily how you would want it or how you think it is best served, but the future, like, what do you think will actually eventually happen? Do you think with the rev share and everything, that's just going to be the final end all be all, or what's going to happen with everything?
I think in the immediate future, we're going to see a lot more calamity. You're going to hear about a lot of war stories, probably a lot more litigation, perhaps arbitration behind closed doors, issues with these contracts that have been signed by and between players and the institutions, perhaps collectives, some of these letters of interest that have more recently been signed with multimedia rights holders, where athletes think that they're getting guaranteed sometimes seven figures, but all it says is that there's going to be an attempt to get approximately a certain amount of money for the players. Um, and the College Sports Commission saying that those deals actually count against that $20.5 million cap. Meanwhile, those schools have already gotten to that cap limit. So I think you're going to see a lot of issues. Ultimately, I believe that at least college football players at the D1 level, college basketball players too, probably just have the look and feel of being employees. I think you're going to find a court of law make that determination. Perhaps it goes through the appellate process. Perhaps it goes all the way up to the Supreme Court. I think at some point in time, you're going to have a situation where there's true bargaining. And if there are restrictions placed on players, they're going to have a seat at the table and negotiate them.
Darren, thank you so much. Really appreciate it. And good luck. I know that this is only going to get more and more complicated, more and more complex. And it's a good thing there's lawyers like you who understand all this stuff because I sure as heck don't.
Again, thanks so much for having me.